I think that in the countries, developed countries, the UK, the USA, there is more an awareness of the branding as something that is very important for your brand or your company.
Hello and welcome to Brandtuned, a podcast for people like you, entrepreneurs, marketers, designers, and business advisors wanting a better understanding of how to design a business and brand. Building a brand that's differentiated and distinctive needs to use intellectual property as an early consideration, a first one, in fact. Brandtuned is hosted by me, Shireen Smith, brand lawyer, author, and marketer. I'd be eternally grateful if you would please subscribe on whichever channel you're on right now. Hello, Alvaro. I'm delighted to welcome you to the Brandtuned podcast, especially in view of your diverse background, which I'm sure we'll go into as we discuss things during this conversation. But for now, I wonder if you could just briefly introduce yourself and tell us a bit more about what you do.
Thank you, Shailene, for inviting me to your podcast. I'm a big fan of your podcast. I always follow it, so I'm very honored to be here. Well, my name is Alvaro Ramirez Bonilla. I was born and raised in Colombia. I became a lawyer in Colombia, but I also lived in France. I lived for many years in France, and I lived many years in um, in the U.S., especially in Miami, and uh, and now I'm also a Spanish citizen. So basically, I started very early in my career working with IP. I started filing my first patent in 1999. So that's like 24 years of practice. And I do practice in a way that is different from most of the lawyers working on IP, is that I lead one of the very few practice that has activities in all the Latin American region.
Okay.
So we handle international clients that want to file at the same time in Mexico, Brazil, Argentina, Colombia, and Peru. So that's the type of clients we have. And well, that so I have quite a bit of experience working on IP, many years, many countries, different clients from all around the world. So
That's good.
I hope I can share this experience with your listeners.
Yes, well, I'm especially keen to discuss the civil law country's approach towards things like, business design, because I know how things work in the UK and US, but when people are designing a business, choosing a name and so on, what do they tend to do in the countries in which you practice? Do they tend to go to a lawyer first? Do they have to register a trademark? How does it all work?
So one thing you have to understand about Latin America is that it's very informal. Most of the economy is informal, so there is a lot of informality. And informals, they don't get lawyers, they don't they get tax advisors, and they after some time, if the business is growing, they will come up with a trademark. Uh, so that can be like 15 years later. No,
Right.
once they have paid all, once they are sure the business is working, that they are making money, that they have bought a new car, that they have all, and then later they will come and see if they if they want to register the trademark. That's for the most of the SMEs. Of course, you have big companies that have a very organized way of creating new brands, and they have big portfolios, and they will make sure the brand is available and ready to use. But that's like the corporate way of doing it, which is basically the one that has been used by all the corporations around the world. And we have some of those very big companies that will take the care of launching a trademark just after they have make sure that everything's in order. But for the smaller companies, the process is very informal. and depending on the sensitivity the owner has to his branding, he will probably go to a designer first. Uh, but it's not always the case. It's just in case he really cares about it, and he will try to build a brand. And sometimes we work with these designers when
Mhm.
they see that they have a client that is serious about it. They want to make sure that everything works. But most of it is just like whatever it works. No,
Okay.
it's
So,
very informal.
so is trademark infringement not an issue over there? I mean, say somebody's using a name that's similar to a big company, would they
So
then need to?
you have like two cases, or you have different scenarios. For example, you have piracy. So you have
Sure.
people
No, I'm not
who
really
makes,
talking about piracy. It's more
yeah,
if by
but
accident they've chosen a name that is too similar to a bigger company.
yes. So if it's similar to a bigger company, the bigger company will make sure that they know that they're infringing the trademark. And actually, it will depend, as it's very informal, it will depend on the grade of formality of the company. If you have a very informal company, they don't really care that much about what can happen. If you have a company that is getting to a bigger size, that have more clients, and you receive a letter of cease and desist from a lawyer, then you probably will pay attention because you don't want to get in trouble. So the system works in not all the countries works the same, but normally people are, when they receive a letter of cease and desist, they will take care, unless they're. I was talking about pirates because pirates they have another business mentality, so
Yes.
they're not they will fix it another way. But most of the company they will have, and depending on the jurisdiction, the remedies can be faster or not. But in general, when two companies that have some stake are in discussion, and they will take care of it.
Okay, so say you have a bigger business that wants to go about things the right way and they want to launch a new brand. Well, do they know that they need to check names, or, do marketers that might work in their companies, do they know about trademarks or not?
Yes, there is a lot of people telling them about that, and the local offices they're promoting the use of trademarks. I mean, there is some trademark awareness. One of the problems we have in some of these jurisdictions is that the fees are very high.
Mhm.
So it's a very expensive process, and most of these early stage companies, or with few years, they don't want to spend the money on it. It's not
Sure.
that they are not aware; it's just that they don't want to spend some money on it because uh, trademark registration is not something they see the value until they get in troubles. Yeah.
Okay.
So
So,
I had clients that with income of, when they reach the $1 or $2 million, they realize they have a trademark, and they want to register, and it happens that they can't.
hmm.
So it's already late. But I think that's like something that happens even in bigger economies and more developed.
Yeah. So if they want to rebrand, would they go to a lawyer, and what's involved really? I mean, how would you help them?
So let's say they already have discovered they have a problem, and they have to change their brand.
Mhm.
So at that moment is most likely that there is a lawyer already involved. And if he's a good trademark lawyer, he will uh, help them to choose a brand that will uh, fit and will not have any problem. And it will help them that way to avoid future problems. But normally that happens after they have a first issue. And so when you have serial entrepreneurs, they already learned that lesson. So next time they do it, they will do it right.
Okay. So essentially, the way I see it is when you're designing a business, you're creating intellectual property because the name is intellectual property, the logo is intellectual property. Um, all the ways in which the business is going to be recognized is protectable through intellectual property, whether people register things or not. So is that similar in your country?
Um, I think that in the countries, developed countries, the UK, the USA, there is more an awareness of the branding as something that is very important for your brand or your company, and more than the legal procedure, they will try to spend some time designing a brand, and they have a clearer idea of what is a brand.
Mhm.
I have to admit that even bigger companies here, even if they have registered their trademark, they don't work that much as a brand. One of the things I do every time I do lectures on this is I try to explain how the brand is the one that creates value and
Yeah.
that will allow the company to have a bigger market share or to have a higher profit.
Okay.
And so I think 20 years ago when I started in trademarks, I was telling me you have to register the trademark, you have to do this and this, all the legal. But now I don't talk about it. I
Yeah.
just say if you manage it right, if you do it the right way, that's the way to capture the
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 value.
value. But I feel that and this is not a generalization because we have very big brands in Latin America. We have Corona for
Hmm.
beer, which is probably one
Yeah.
of the most well known. Um, we have different brands in the region that are famous. Juan Valdez for coffee in Colombia.
Hmm.
So these people, they are very serious about it. So I'm not talking about those cases because those they know how to play. But most of the companies sometimes they focus more on producing than on the branding. and and I always tell them you have to learn about the branding, you have to learn how to add value, to see what clients are looking for, how you want to create this brand that is going to make you sure that you can sell more or and have a higher margin. But it's something that is not completely aware. There are very few brands that are created already with that on mind. Most likely, they just put a name that
Yeah.
seems to them nice, but they most of them they don't focus that much on branding.
Okay, it's a question of degree, I think, because there are also a lot of businesses who don't really understand what a brand is. They think it's a logo here in the UK. But let's go back to you yourself. When did you start your own business, and what did you do for your business when you started?
Well, actually, it started when I was very young. I was at law school. That was
Oh,
in time 99, and at that time I wanted to start. That was the time of the dot-com
oh
boom.
yeah. Uh-huh.
Yeah. So I was focusing on building my own dot-com company in
Oh,
99. So I was studying law, but I started taking business classes.
uh-huh.
And I took one of the first e-commerce class that was in Colombia. And there was a guy in my class that got sued for domain names.
Oh,
And that was the first time there was one of these cases in Latin America. So nobody knew about it.
uh-huh.
So this guy came to the teacher and told him, "Look, I'm starting this library online, and I receive a letter from this big law firm. What do I do?" And the teacher said, the 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 only lawyer or the only law student here is Alvaro. So talk to him."
Oh,
And I have to admit, I have no idea, no clues of trademarks, no clues of domain names. But I say, okay, I will help you.
mhm.
And he was one of these very big law firms, and I was a law student, and I won that case. So
Really?
yeah, so
What was
that's
it?
how
A
I got
dot
into.
com? Was it a dot
Uh,
com domain or
yeah,
what?
it was papiros.com. It
Mm,
was very what that was in 2000. So the domain name system dispute started in 99, and this case was in February 2000. So it was very
mm.
very new. So that's how I got involved into IP. And
So
later I
who was wanting
uh,
them to stop using their domain?
so uh, there was there was another startup which was
Mm.
founded by some important people, and they were using the brand Papiros, and it was papiros.com.co at that time. but this student found that he was looking for some books. He put Papiros online. He knew that it was available, and he registered. Actually,
Uh-huh.
he was not using it. But that's interesting because the company which was founded and had venture capitalists didn't have the trademark.
Right.
So they haven't
They
registered
hadn't
the
been
trademark.
using the name either.
They had used the name, but
But not
well,
long.
I don't remember the details of the
Yeah.
case. Like it's 20 something years ago. But let's say it was not an easy case.
Yeah.
So when I won it, it made me a little bit famous. So let's say that I was still in law school
Hmm.
and I was able to take care cases as Avianca.com, which is one of the oldest airlines in the world. That is the second oldest airline in the world after KLM, one of the biggest in America. So that was one case I handled while I was still in law school.
What, another
Yeah.
domain issue?
Yeah, domain Avianca.com, which now values millions. No,
Oh,
uh,
so you
so
developed a
that's
specialism in domains.
so yes, in the early 2000 there was a lot of activity with
Yeah.
that because all the companies that realized they had to come to the
Hmm.
digital world,
Yeah.
they didn't register the domain names, and there was a lot of people that the people who knew a little bit more what was happening on the internet start registering those names,
Mm.
and it became like it became a problem for the companies. But now, I mean, now we have a lot of domain names. It's not an
Yeah.
issue as it was at that time.
So that got
Yeah.
you into trademarks and IP,
So
did
so
it?
that's how I got into trademarks and IP.
Yeah.
So then I got my first client, which was from South Africa, and at that time I didn't have a name,
Hmm.
and it was like very serious law firm. I'm not giving the name, but so they asked me something, and I had to create my first brand in a night, working to be to
Hmm.
look more professional. That was 99 years ago. In 99, so that was 24 years ago.
Wow.
So
And
that's
what's
how
your
I
name
started.
now? The name of your business?
So the name is BR Latin American IP.
Uh-huh.
BR for my family name and Latin
Right.
America because we focus on Latin America. So
Right. Wow.
that's the name.
So have
Yeah.
you registered your trademark?
Oh yes, I do. And I even have various as a lawyer. I have
Mm.
two more brands.
Hmm.
So I the way I is the way we work is that we give to each practice their own brand.
Okay.
So we have also an immigration practice,
Mm.
and it's called Plan B
Okay.
dot legal. Yeah, so that's for
Oh,
the immigration, and we have another for corporate investment finance brand, and it's called Bonilla. So we have different brands in the company. So I probably one of the few lawyers that has three brands for the same law practice. I mean, the same corporation and the
okay.
same team
So
for most of the things
very
that I do have.
entrepreneurial, it sounds like.
Yes, I am. Thank you.
Good. Well, actually, one question I have is the law in most countries that I'm aware of is that if you pay a third party, a service provider to create something for you, like software or a logo, you don't own the copyright in it unless you get it assigned to you in writing, or they are your employee. Well, how does it work in Latin America with that sort of
Yeah,
work, having a
I
copyright
I
work?
I have to tell you that I never been aware of a case where the designer sued the company for using the brand they designed
Uh-huh.
based on copyright. So is well accepted as a business practice. Maybe if you go to the legal details, you're gonna come to a different conclusion. But is well accepted as a business practice that once you get paid for creating a brand, that brand is no longer yours, and you cannot claim any rights. Now, if you go to the legal side of it and you start like question may rise that the brand can be from someone, but the copyrights are from someone else.
Mhm.
Yes. And normally, depending on the country, you will need some formalities to transfer or not. If it's considered a work made for hire, or work made by an employee,
So
that will
if
be
it's
a
a
different
work made for
situation.
hire, you would get an assignment of the copy. Say it's software, which matters.
Yes, so that was a big discussion for a long time, and I work on software for a long time, and for works made for hire on software, normally you need to have a proper assignment of rights.
Mhm.
That has been changing lately, and they have in Colombia. I'm not telling about other countries, but in Colombia they have arrived to a conclusion that work made for hire applies to bigger works like a software. Uh,
So
so
what does that mean? Work made for hire.
it
What?
means something that you requested somebody to make especially for you.
Mhm.
No. So if I ask you to design my brand and I give you the instructions and the general idea of what I want, and you're building it because I hire you, and you get compensated for that. So that will be considered as work for hire.
So does
And
that
in
mean you don't own the copyright, or do you still need to?
and that means that when you have the work made for hire, you own the copyrights.
Okay, so if I hire
Some of
somebody,
them, no, you have the copyrights that you can never transfer. That what we have in this civil law is you know that we have like two type of copyrights. You have copyrights related to money issues; those can be transferred, and other copyrights the that we call moral copyrights that
like if
cannot be
you've
transferred.
written something or painted something, you have moral
Yeah,
rights.
yes, you have the one of the moral rights is the right to be considered the author.
Mhm.
No,
So you can
so
never get
you can
rid of.
never give that away.
Mhm.
I mean, the brand can be from the company, and they have the right to put it wherever they want, but they can never say that if they are asked, they have to put the name of the person who designed it.
Doesn't that mean another designer can't then rework the logo if the company wants to change the logo? Can they get a different designer to rework
I
it? Or-
I haven't. I mean, I understand completely what you're saying, and this is something that it can happen. I
Mhm.
mean, legally, if they change the the work in a way that it affects the morality of the intellectual rights of the first created, eventually he can do it. I haven't seen a case like that. I seen it in the books, and I think if somebody wants to fight, maybe they will have something. Uh, but I hardly see that it's gonna go very far. And there is something that is different from civil law. For I don't know how it's in the UK, but in the US, there is this incentive to sue because you're planning to get millions of dollars, and everything's like huge, and no, so so you're trying to become rich with legal action in these
Well, yeah, you
countries.
would if there's a very important piece of software that you've written. Um, in the UK, if the software developer didn't assign the copyright, then the user can use it, but they can't sell it to third parties. Only the copyright owner could sell it unless they've
Yes,
assigned copyright in it. So
yes,
I
and that's
want to
exactly the same
understand
here.
that's the
I mean,
same
that's
there.
exact. I mean, if there is not a mechanism that it was assigned to the other person,
Mm,
you will have problems. I'm telling you that sometimes they can be very strict. For a very long time, Microsoft was not considered the owner of the copyrights of
really?
their software because they
Mm,
didn't bring the assignment of all the thousands of
mhm,
software engineers or coders that
yeah.
participate in that product. So for some time, it worked like very difficult for companies. Then Colombia signed a free trade agreement with the U.S., and there was a special chapter on on copyrights. Actually, it was part of the team that negotiated that agreement in that chapter. and one of the concerns the U.S. had, was exactly that they made the life very difficult for corporation to own the copyrights of the employees.
Mhm.
So, for example, in the case of Colombia, that we moved to a position where it's easier for companies to make sure they are the owner of the copyrights of the software. And I work a lot on software. I think, and that's my personal opinion, that the approach we have in Latin America, that we put software protection as a copyright protection, is not the right way to do it. You have also, we don't have patents on software,
Mm.
uh, but
You
I
need to
think we
register copyright in Colombia. Is it a country where copyright needs to be registered?
know,
No.
like most of the countries that are part of the convention, uh, you don't need to register to get the rights. You get the to register, but there is a public registration system that works just to make sure it. I mean, just to help you in case you have to prove. So that will be evidence that you are the copyright owner. But it's not the one that creates the right. What creates the right is the fact that
Yeah, you
put
create.
it that you create it and you put it in a way that can be reproduced. You know.
Okay.
So so the copyright works like that, and for a long time we were very protective of the authors, and but now we are have shift more to protecting the company, especially on the software side. And I think it's right because the software is nothing like a book or a painting. I mean, it's created by a person, but it
Yeah,
has
it's not a
a painting.
creative work in the same way as a piece of
Maybe it's
writing.
a creative work. I mean,
Yeah,
I myself, I know how to write code, and I know that you can write the same function in different ways. Yes,
yeah.
and there are some ways that you write a code that is going to be faster than another, and that's probably very valuable. Um, so
Mm.
there is creativity inside, but paint or a book doesn't change in time. Doesn't need to change in time. It's already fixed,
Mm.
and that it should be kept like that. But a software that doesn't change in time is a software that is going to die.
Yeah, you
So
need to be
you
able
need
to
to
change it.
make sure that you can modify it.
Yeah,
A book, or I say a recipe on a book recipe, is not able to cook, but the software is able to perform something.
yeah.
So it's completely different. And I support the idea that should be like a special copyright or a special legal treatment for software, different from what we do with
Mm.
books. And they put it there because they didn't have a place to put it. So they once they have the problem of what we do with copyrights, we put it with software rights. We put it with the copyrights, but it's not the place it should be, in my opinion.
Mm. Yeah, I know what you mean. So, in terms of names, do people tend to choose descriptive names and then find later on that they essentially have nothing that they can protect, that they can't
Yes,
stop other people using similar names? How does
that
that
that's
work?
that's funny because actually I wrote something called the empanada. How do you the patty, the patty.com. I wrote an article about that, and so
Mhm.
everybody, there was like a trend in a time that
Mhm.
you use the as brand the name of the place. So you have the restaurant.com, the
Oh, yeah.
disco.com.
Well,
No,
actually, the .com boom was full of that, pets.com and agency.com and all that.
yeah. So at that time, exactly. So everybody was trying to get like the .com and try to build a brand around that. So that's something that still happens. It is being less of a trend lately. At the beginning with the .com, it was like that.
Yeah.
No,
But I
um,
find people's tendency is to choose very descriptive names.
yeah, but
Um,
it stays like
is
that.
that
Yeah,
the same over there? That
exactly the same. There is most of the cases there is no more creativity.
mm,
So
So
if
you can't
you
protect such a name. I mean, competitors
exactly.
use it.
Exactly. You cannot, in case you do it, you have a very weak trademark, no?
Yeah, yeah.
So that's something to avoid. And I always tell them try to get something that is not that obvious and so descriptive.
Well,
Um,
I find actually that often designers and marketers make the same mistake as business owners. Many of them tend to choose very descriptive names.
yeah, I don't know if actually I'm not sure is that a big mistake because, and this is something, as you say, I'm an entrepreneur, so
Yeah.
I, I tend to, I you know, for some companies it's important to have a brand, but for others it's not that important. What is important is to sell, you know, and not all the business react the same to branding. So if you have like a hot dog place that sell hot dogs in a corner close to a metro station, the brand is not really important. And you can put a big announcement that said hot dogs, and that's the only thing that is matter because you don't really need a brand. What makes people buy and use your location, and it happened with other things. Is sometimes it's not that important the brand, but it's more important how they get. For example, and this is related to email, to marketing, to digital marketing. It's
Mm.
more important to be registered as ranked in Google is more important than having a non-descriptive trademark. So let's say you and I were lawyers, so we get our brand will be
Keyword rich
trademark
name.
lawyers.
Yeah.
Yeah, because people will not look for your name; they're gonna look for a trademark lawyer. And if you get like the a trademarklawyer.com, you will come up first in the search.
Yeah,
So you
that's
can
part
say
of
a
the reason.
trademark lawyer is a very bad brand because it's completely descriptive, but the client say, I don't really care because what I care the most is to be ranked in Google.
Yeah, but
Yeah.
except when Google then changes its approach, like books.com, doesn't appear if you're looking for books. There was a time when if you had books.com, you would always be at the top. Um,
Yes, but it's still the name of the domain name has some influence on the search engine optimization, and also when you're looking for search engine on media, on social media, or when you're looking, I mean, the name has some weight on the way they're looking for. So I think for those companies is good. I mean, it's better when you have Amazon. It has no relation with anything.
yeah,
You have a big brand that everybody is on top of mind of people. But for some companies, sometimes the strategy is the other, and some other companies they have, for the same services they have different brands, and they
yeah.
just try to see which one works better. Yeah.
I think it's
So
important to decide what your ambition is when you are starting a business, really. But for a business that has aspirations to become bigger, to become maybe like Amazon, then starting with a descriptive name isn't going to cut it. Maybe they could experiment for a while to test their concept. But essentially,
I
without a brand name, they're not going to get very far.
I totally agree with you, and that's what we tend to tell our clients. But lately, I discovered the other brands because there are brands that are very descriptive that cannot be registered brands, but they sell. No, and they sell a lot, and the name that you think is not very important sells. Now, the problem of these brands, they're weak, and somebody can
Copy.
can copy it, and so
Well, that's the
we
problem.
as lawyers tend to say no. You can sell, but the day somebody notices that you're selling too much, they're gonna try to copy you, and you will not have that many options because your brand is so
Yeah.
weak
Or they
that
have a
that you
very expensive litigation. They will
yes.
sue, but they haven't really got strong rights. So they end up spending a lot of money suing, but
Yes,
where
but
essentially, yeah.
yes, I totally agree with you. I mean, I understand exactly because that's what I tell my clients. But from my business perspective
Hmm.
and what I see is, as I told you, people don't register their brands until they're sure the brand is making money.
Mm.
No,
Yeah.
at least enough to pay all the fees. And
Hmm.
I mean, if you don't have investors, probably you have investors, you do it from the beginning. But if it's like an organic company that is growing on their own income,
Yeah.
they will not spend, they will not care that much at the beginning of the brand. And if it's descriptive or not, they just care if it sells or not, because they need income to keep going.
Mm.
Later, at some stage, they will discover the brand was not that good, or they probably is already being registered by another company,
Hmm.
or they have a problem. But it depends, as you said, it depends mostly on what people are saying. If people are
Mm.
um, they need to launch something fast, and they have if they have a product that has the name, and they will probably have the selfie stick store,
Yeah.
is better than a name that nobody can relate to the selfies, and so they have to do
Yeah.
a big effort to brand it.
Yeah, I
And some
mean, obviously, some names are excellent for marketing purposes, but not for branding purposes. But it's
yes,
not knowing this is the issue. You know,
yes, as
you
long
need
as you
to
know
know
what
what
you're
you're
doing.
doing. Yeah.
Exactly, as long as you know that you're doing. So yeah, so let's say you have the selfie sales stick
Hmm. Selfie stick.
store.
Mm.
Selfies. Okay.
Yeah.
So if you have that brand, like, or the
Yeah. And then
the
you're surprised
microphone
someone
store,
else.
and
Yeah.
the microphone store works very good, but somebody comes and comes and say the Microsoft Store 2, then you have a problem,
Yeah.
because all the effort you have
Put it.
done,
Yeah.
put it, is gonna be going to
Wasted.
the competitors, and that's not because of the competitors, your fault.
Yeah. So
So some
really,
strategies that at the beginning seems to make sense, later on maybe they don't.
they don't. But it's
Yeah.
really understanding what you're doing is the important thing. And by the sounds of it, the principles are pretty similar, whether you're located in the UK or Colombia, in terms of understanding the approach, whether you're going
Yeah.
to be using a descriptive name or not.
I work on trademarks in different countries, and I do it because it's easier.
Mm.
No, if I was going to do family law, that would be very complicated, because every single jurisdiction will have their different rules. But
Yeah,
intellectual property, after we have the TRIPS agreement, and we have
yeah.
all these Paris Convention, and we have all the
The
Geneva
Berne
Convention, and you have all
Convention.
these, so they're basically very similar, and
Yeah,
the so it's easy to understand how it works mostly in every country, because
yeah.
you have
Well,
some small difference, but it's basically the same.
this is actually the problem I see with IP is that people assume it's just law, and therefore they don't teach it in business schools. They don't include IP, or if they do, they talk about patents. But the IP that's relevant to brands is actually business design. It's not going to be different in different countries. And that's really what I'm trying to do, is to prove somehow that these principles are the same the world over. They're not about whether you're UK law or US law. There are some principles that are very similar wherever you are, and that should be taught by business schools to their students.
I totally agree. We are developing a IP program for a business school here in Colombia, and I was invited many times to MBA classes, and uh, and that's something that is important, because people are not always aware of how it works, and
Mm.
the basic rules, no,
Yeah.
and so the marketers, they basically have no idea of it.
Mm.
And I should think everybody in marketing
Should
should
know.
know
Yeah.
something about it. It's
Yeah.
like everybody that works on contracts has to know something about taxes. No?
Yeah. Or if you're a journalist, you have to understand the laws that apply to journalists, so
Yeah. If you're the journalist that covers a court, you better know the
yeah,
procedures of the court. No?
yeah,
So I think market is should have a better understanding, and that's probably something that still space to work with them on
Yeah, and
showing
also
the rules.
business schools really need to introduce it in their programs because they teach MBA students, and at most they might invite a lawyer to speak for an hour or two, but that's not enough, you know.
Yeah, but that's something, and this is a discussion that, I was a lecturer in universities for many years, and
Mhm.
now they don't invite me anymore. And I don't accept invitations neither, because the first thing I say to these law students is, you're wasting your time here.
Why is
You
that?
when Why? Because when you come, let's say you become like the in-house of a company, nobody will pay attention to you. You will be like the guy who doesn't allow to do things. No, you're
What,
gonna
this is
be
law
so
students?
huh?
Are you speaking to law students or what?
To law students. Yeah. First of all, I say there is too many lawyers.
Hmm.
Second, we are becoming more irrelevant because of all these AI things. I
Mm.
Yesterday my wife asked me if I can help her with a contract. I say ask ChatGPT is gonna do it better than me and faster. No. So she got her contract for a small thing. She needed to have like a small disclaimer for something. I said go to ChatGPT and do it. So you have all these AI is gonna take away most of the work lawyers normally do,
Mm.
and it's already happening. I mean, took less than a year to happen. You know,
Mm.
uh, there are too many lawyers. There are AI replacing most of the lawyers' work, uh, and there is something about our lawyers is that we are not perceived to add value. No,
Yeah, it's
it's like
regarded as a cost, an overhead cost or
we are exactly. So the lawyer is somebody you have to pay because otherwise maybe you get a sanction or you get a fine or yeah. But he's not somebody who adds value to the business, and is like a big challenge. So you said that in MBAs they should teach law, and I always said, and for lawyers they should teach the business, because if you're
Mm.
a lawyer and you don't understand the business how it works, then
Yeah,
you
I
will end
agree.
up becoming the no guy. You cannot do this, you cannot do that, and nobody wants to hear him. I mean, maybe they can pay it, but they will pay as low as possible, because he's not somebody that helps you. And then you have the marketing guy who comes and say, we're going to do this and we're going to do that, and the sales guys who brings the money. So everybody in that team is more important than the lawyer.
Mm.
No.
Yeah.
So that's what I'm saying to my students. You can be probably the smartest guy on the room, yeah, who has a better brain, that has a better way of interpreting I mean, understanding. You have spent. I studied both at the same time. I studied law and business at the same time, and for me, the marketing class was right on the woods. I mean, it was nothing compared to what I was doing when I was studying law. Law was like very dense and
Yeah.
difficult and
Mm.
complicated, but marketing was very easy.
Mhm.
But now I understand that maybe that no, I'm sure the classes I took from marketing helped me better than the ones I for business purposes and for making money and for making a life
Mm.
earning that the law. So that's what that's and I think that, and this is becoming something I see on my colleagues and even on myself. Sometimes we get frustrated,
Mm.
and and lawyers can get very easily frustrated because they think, look, I'm smarter than all these guys. I know more things that they do, but still their voice counts more in the committee. Still, they make more money than I do. No, because for the business company, the lawyer is somebody who is just next to the accountant. No, something that we need, but is
Mm.
not very important. So I'm sorry. So when I start saying that, they stop inviting me to giving classes in law school, and you're probably not
Well,
going to invite me
I
to this
believe in
podcast again.
I believe in a multidisciplinary, interdisciplinary approach because society is getting too complicated to just be in your own lane. You need to understand wider perspective.
Yeah, exactly. So that's what I think. If you're going to become a business lawyer, no,
Mm.
because IP lawyers were business lawyers.
Yeah.
Uh, you need to understand business. And I will also put on the IP a lot of the marketing. Yeah, they have to combine. So marketers have to learn more of the legal, and lawyers need to understand more of the marketing and the way companies work. And if you're able to understand too, then when you come to a committee and you say something intelligent, they will value you. No? Because you're gonna add something to the discussion, and you're not gonna stick on your only subject.
Great. Well, it's been lovely interviewing you. Thank you for appearing. Before we close, what is how would you define what a brand is?
And that's like the easy and complicated question, no? Like so simple that it should be complicated. I think as the brand as a value store is where you put all the efforts you do, and you put it in a box. It's like your saving box. So everything, that all the marketing, all the good products, all the good service has to come to this place. And if you do it right, it will spend and it will bring more money. So I see it as a place where you store value for your clients. Yeah.
Yeah, that sounds brilliant. Okay.
Thank you, Shireen.
People will have positive associations as a result.
Yes, it's not something, because you can also say a trademark is a procedure. I mean, is something that you have to register. No, so it sounds like boring, and it sounds like it doesn't. Is like I just have to pay something more. No.
Whereas it actually contains that value. It's when you sell a business, essentially you're selling the name. Is a big part of what you're selling.
Exactly. If you do it in the right way, it has value. And one of the companies I do have, I mean, one of the brands I have, the one Bonilla, is the one that works on trademarks valuations and business strategy related to, but seeing from a financial side, no? So that's the thing we do. We try to see what's the value of a trademark. And sometimes it's very difficult because you cannot separate the value of the trademark from the value of the company.
Yeah.
Because it's the same. And we try to talk to very sophisticated clients about how to create a different value from the brand, different from the company. Yeah. So it can become a different asset, because some of the times you cannot sell the brand without selling the company if you don't do it on the right way. Okay. You have to do it in a way that you can sell the company and sell the brand apart and have different values.
Wow. So you have your fingers in many pies. Great. Well, thank you very much for coming to the podcast to have this chat.
Okay, Shireen. Thank you. I try to see things from many perspectives. And I think the financial perspective is one of the most important and less known. You have the marketing perspective, but you have also the financial. If you try, and that's like the next step we should go. Try to, if the guy is if the lawyer knows about the strategy for making that asset something they can see on the accounting books, then he will make sure they like him.
Yeah. Good. Well, thank you very much then.
Okay. Bye, Alvaro. Thank you, Shireen. Bye.
That's it for this week. The one request I have of you is to subscribe on whatever channel you're listening on. Thank you and bye for now.